Welcome back. South African actors say changes to copyright law would give them residual income in the form of royalties during the COVID-19 outbreak. But the European Union and the US are putting pressure on President Cyril Ramaphosa to ditch the copyright amendment bill. The 28th of March marked a year since the bill was approved by Parliament and the National Council of Provinces, clearing the way for the president to sign it into law, but he's yet to do so. Aviwe Mtila is following the story for us. He joins us now live. So Aviwe, you spoke to officials in the acting business. What are they saying?
Well, basically, Shahan, they're saying that during these tough times, of course, of the testing pandemic, coronavirus pandemic, they're saying that with the scarcities of jobs, they would be getting paid if this copyright amendment bill were to be pushed through. Essentially, you'd understand that the bill has been with the president from the 28th of March last year, and they're saying that now they'd be in a position to earn through the work that they've done already through royalties. I got a chance to pick up there with Jack Devnanara, who is, of course, the SA Guild of Actors chairman. Let's listen in on what he had to say there.
In this country, actors do not have a statutory right to earn royalties, unlike actors around the world who do have that right. South African actors do not have the protection that's afforded to them by the statute. And I suppose the biggest, most important aspect, speaking in economic terms, is that South African actors will then have the right to earn royalties. And royalties basically mean that every time a show, a TV series is shown around the world, it's sold to other territories, that the actor would earn a percentage as a residual income. And in these terms, that's what's known as royalty, and we will be able to earn something for the exploitation of our work. And it's interesting to see, though, that right now, while collective management organizations are making royalty payments for musicians, for composers, actors who are no less a part of the creative economy have been denied that right for so long. And it's a desperate situation now, especially when so many actors are stuck due to restrictions of COVID-19, unable to earn an income, desperate for grants, desperate for food, desperate to try and meet our commitments to pay rent, to keep our households going, that we are unable to earn an income from work that we've already done.
So the president is facing international pressure not to sign the bill, though. Tell us why.
Well, Shahan, you'd understand that those in the know-how suggest that this is a double-edged sword. You'd understand that while the actors seemingly would be benefiting from it, the publishers and your authors, experts suggest that they'd be extremely in a catastrophic position where, in fact, they wouldn't be earning that much. You'd understand that this copyright amendment bill would suggest that it would ease up, in fact, some regulations which would allow and benefit users, essentially, as opposed to the authors themselves. If those materials, the authors' materials, in fact, would support educational bases, they would be then allowed to be accessed freely without payment even. So they suggest that, in fact, even investments coming into the country when it comes to your movies, in fact, also an organization in the US already has touched on it. The International Intellectual Property Alliance in the US has raised it up with authorities in April already, where it's been taken up, which suggests that investment could be hampered with this. But let's listen in to copyrights lawyer Stephen Hollis and what he had to say on this.
In America, there was a complaint brought by the International Intellectual Property Alliance called the IPA. Now, they represent, they're a trade association that represent all the major players in America in the creative industries. So, for instance, the movie business, you've got the publishers, you've got the music companies, the gaming companies, etc., saying, we feel that if this bill is going to be passed into law for some of the reasons we discussed, we're going to lose a market in South Africa because we won't be comfortable anymore to actually invest in that jurisdiction, because we won't recover our high-level investments and we won't be able to enforce our rights against users who will have too many rights to access for free. Okay? Now, that complaint was brought to the office of the USTR, which is the United States Trade Representative Office, and for them to investigate whether this bill, if signed into law, would in fact place South Africa in breach of its obligations in terms of the AGOA trade deal and the GSP, which is a generalized system of preferences, duty-free access to American markets. Because what they're essentially saying is, in terms of that AGOA agreement, unless you provide adequate intellectual property protection for American companies, then you're in breach of that agreement.
All right, we'll leave it right there. I'll be Mtila.